We shall commence this module by discussing the Competition Act 2002 in brief. The Competition Act 2002 contains 66 sections which are classified under 9 chapters. Chapter 1st contains 2 sections under the heading Preliminary Chapter 2nd under the heading of Prohibition of Certain Agreements, Abuse of Dominant Position and Regulation of Combinations contains sections 3 to 6. Chapter 3rd under the heading of Competition Commission of India contains section 7 to 17. Chapter 4th dealing with duties, powers and functions of commissions contains sections 18 to 40. Chapter 5th under the heading of Duties of Director General contains section 41 only. Chapter 6th under the heading Penalties contains sections 42 till 48. Chapter 7th dealing with competition advocacy contains section 49 only. Chapter 8th dealing with heading Finance, Accounts and Audits contains sections 50 to 53. Chapter 9th dealing with heading Miscellaneous contains sections 54 till 66. The Competition Act 2002 has so far been amended twice, first in 2007 and secondly in 2009. After starting this chapter, you should be able to understand the Competition Act 2002 at a glance, meaning of competition and the objectives of the Competition Act 2002, meaning of anti-competitive agreements, agreements deemed to be anti-competitive and those not deemed to be anti-competitive, meaning of dominant position and what matters are deemed to be abuse of dominant position. Detailed provisions related to regulation of combinations. Let us understand the meaning of competition. It is a situation in a market in which sellers independently strive for buyers' patronage to achieve business objectives such as profits, sales or market share. It is the foundation of an efficiently working market system. Now, we shall understand the objectives of the Competition Act 2002. As per the statement of objects and reasons, the Competition Act seeks to ensure fair competition in India by prohibiting trade practices which cause appreciable adverse effect on competition in markets within India, and for this purpose provides for the establishment of a quasi-judicial body to be called the Competition Commission of India (CCI), which shall also undertake competition advocacy for creating awareness and imparting training on competition issues. It also aims at curbing negative aspects of competition through the medium of CCI. It also provides for investigation by the Director General for the Commission. The Act confers powers on the CCI to levy penalty for contravention of its orders, failure to comply with its direction, making of false statements or omission to furnish material information, etc. The Act also seeks to create a fund called the Competition Fund, for which grants are given by the government, out of which the pay and allowances and other expenses of the Commission will be borne by the Commission. Thus, based on the above, it may be concluded that the ultimate objective of the Act is to secure the best interest of consumers. It empowers the consumers and best guarantees the consumer protection. The advantages of the perfect competition are threefold. Allocative efficiency, which ensures the effective allocation of resources. Productive efficiency, which ensures that the cost of production are kept at a minimum, and dynamic efficiency, which promotes innovative practices. These factors by and large have been accepted all over the world as the guiding principles for effective implementation of the competition law. As per the preamble of the Act, it requires not only the protection of free trade but also the protection of consumers' interest. Let us now discuss the Anti-Competitive Agreements Section 3. The important aspects are as under. What is an anti-competitive agreement? There is no specific definition of the expression anti-competition agreement, but it can generally be defined as an agreement which is contrary to or is inconsistent with the competition policy advocated in the Act. Section 3 prohibits the anti-competitive agreements and hence states that no enterprise or association of enterprises or person or association of persons shall enter into any agreement in respect of production, supply, distribution, storage, acquisition or control of goods or provision of services which causes or is likely to cause adverse effect on competition in India. Agreements deemed to be anti-competitive. Subsection 3 states that certain agreements shall be deemed to be anti-competitive. These are the agreements or certain practices carried or decisions taken including cartels engaged in identical or similar trade of goods or services which a. directly or indirectly determines purchase or sale prices, b. limits or controls production, supply, market, technological development, investment or provision of services, c. shares the market or source of production or provision of service by way of allocation of geographical area of market or the type of goods or services or number of customers in the market or in any other similar way, or d. directly or indirectly results in bid rigging or collusive bidding, shall be deemed to have an appreciable adverse effect on competition. Subsection 4 also states that any agreement related to production, supply, distribution, storage, sale or prices of goods or provisions of services including a. tie-in agreement, that is an agreement requiring a purchaser of goods to purchase some other goods, b. exclusive supply agreement, that is the agreement restricting the purchaser to deal in goods of any other supplier, c. exclusive distribution agreement, that is an agreement to restrict, limit or withhold the output or supply of goods or to allocate any area or market for the disposal or sale of goods, d. refusal to deal, that is the agreement to restrict or limit the persons or class of persons to whom goods are sold or from whom goods are purchased, or e. resale price maintenance, that is the agreement to sell goods on the condition that the purchaser shall resell the goods purchased at a certain price only, shall also be deemed to be anti-competitive if such agreement causes or is likely to cause an appreciable adverse effect on competition in India. Next are the agreements not deemed to be anti-competitive. The following shall not be deemed to be anti-competitive. A. Any joint venture agreement if such agreement increases efficiency in production, supplies, distribution, storage, acquisition or control of goods or provision of services. B. The right of any person to restrain any infringement or to impose reasonable restriction which are necessary for the protection of rights conferred upon that person under the Copyright Act 1957, the Patents Act 1957, the Trade and Merchandise Marks Act 1958, the Geographical Indication of Goods Registration and Protection Act 1999, the Designs Act 2000 and the Semiconductor Integrated Circuits Layout Design Act 2000. C. The right of any person to export goods from India to the extent to which the agreement relates exclusively to the production, supply, distribution or control of goods or provision of services for such exports. Now moving on to discuss the abuse of dominant position. Section 4 of the Act prohibits the abuse of dominant position. The important aspects related to abuse of dominant position are as under. Now what is a dominant position? Dominant position means a position of strength enjoyed by an enterprise in the relevant market in India which enables it to A. Operate independently of the competitive forces prevailing in the relevant market, or B. Affects its competitors or consumers or the relevant market in its favor. Next is what are deemed to be the abuse of dominant position. What matters shall be considered to be the abuse of dominant position are given in section 4 subsection 2 of the Act. These are the matters in which an enterprise or a group A directly or indirectly imposes unfair or discriminatory first condition in purchase or sale of goods or services. Second, price in purchase or sale including predatory prices of goods or services. Now, predatory price means the sale of goods or provision of services at a price which is below the cost with a view to reduce competition or to eliminate the competitors. B. Limits or restricts first production of goods, second technical or scientific development, or C. Indulges in practice resulting in denial of market access, or D. Makes conclusion of contracts subject to acceptance by other parties of supplementary obligations, or E. Uses its dominant position in one relevant market to enter into or protect other relevant market. But it has been clarified that unfair or discriminatory condition in purchase or sale of goods or services, or unfair or discriminatory price in purchase or sale of goods or services shall not include such discriminatory conditions or prices which may be adopted to meet the competition. Now we shall understand the regulation of combinations, section 5 and section 6. Section 5 of the Act deals with combinations which may create adverse effect on competition in the relevant market in India. As per this section, the acquisition of one or more enterprises by one or more persons or the merger or amalgamation of enterprises shall be such combinations under the following circumstances. First, where parties to the acquisition acquire control, shares, voting rights or assets of an enterprise A in India, where the value of assets is more than rupees 1000 crore or the turnover is more than 3000 crore, or B, in India or outside India, the aggregate value of assets is more than 500 million US dollars, including at least rupees 500 crore in India, or turnover of more than 1500 million US dollars, including at least rupees 1500 crore in India. Second, where the group acquires an enterprise whose control, shares, assets or voting rights will belong after acquisition jointly. A. Either in India, in which case the value of the assets is more than rupees 4000 crore or turnover more than rupees 12,000 crore. B. In India or out of India, the aggregate value of assets is more than 2 billion US dollars, including at least rupees 500 crores in India, or turnover more than 6 billion US dollars, including at least 1500 crores in India. Third, where a person acquires a control over an enterprise when such person has already direct or indirect control over another enterprise engaged in production, distribution or trading of a similar or identical or substitutable goods or provision of a similar or identical or substitutable services if A. The enterprise has a direct or indirect control jointly. A. Either in India, the asset, the valuation of which is more than rupees 1000 crore or turnover is more than rupees 3000 crore, or B. In India or outside India, the aggregate value of asset of which is more than 500 million US dollars, including at least rupees 500 crore in India, or turnover is more than 1500 million US dollars, including at least rupees 1500 crore in India. Fourth, where acquiring control by a group over an enterprise which will belong after the acquisition jointly, it would have either in India the assets, the value of which is more than rupees 4000 crores, or turnover is more than 6 billion US dollars, including at least rupees 1500 crores in India. Fifth, where the enterprise after amalgamation or merger may have A. Either in India the assets of the value of more than rupees 1000 crore, or B. In India or outside India the aggregate value of the assets is more than 500 million US dollars, including at least rupees 500 crores in India, or turnover is more than rupees 1500 million US dollars, including at least rupees 1500 crore in India. Fourth, where the group after merger or amalgamation will belong to the enterprise and it will have first, either in India the assets of the value of more than rupees 4000 crore or turnover of more than rupees 12,000 crore, or second, in India or outside India where the aggregate value of assets is more than 2 billion US dollars, including at least rupees 500 crore in India, or turnover is more than rupees 6 billion US dollars, including at least rupees 1500 crore in India. For the purpose of this section, the following terms have been defined as under. Meaning of control. Control includes controlling the affairs or management by first, one or more enterprises either jointly or singly over another enterprise or group. Second, one or more groups either jointly or singly over another group or enterprise. Next is meaning of group. Group means two or more enterprises which directly or indirectly are in a position to first, exercise 26% or more of the voting rights in the another enterprise, or second, appoint more than 50% of the members of the board of directors in the other enterprise, or third, control the management or affairs of other enterprise. Next is manner of calculation of the value of assets. The value of the assets is to be determined by taking the book value of the assets as shown in the audited books of accounts of the enterprise in the financial year immediately preceding the financial year in which the date of proposed merger fails, as reduced by any depreciation, and the value of assets shall include the brand value, goodwill value, value of copyright, patent, permitted user, collective mark, registered proprietor, registered trademark, registered user, homonymous, geographical indication, design or layout design, or similar other commercial rights. Regulation of combination, section 6. Section 6 provides that no person or enterprise shall enter into a combination which causes or is likely to cause an adverse effect on competition within the relevant market in India, and such a combination shall be void. Section 6 relates to regulation of combinations and the effect thereof. Any person or enterprise who or which proposes to enter into a combination shall give notice in the prescribed form together with the prescribed fee to the Commission, disclosing the details of the proposed combination within 30 days of A. The approval of the proposal relating to merger or amalgamation by the Board of Directors of the concerned enterprises. B. The execution of any agreement or other document for acquisition or for acquiring control over an enterprise. No combination shall come into effect until 210 days have passed from the day on which the notice has been given to the Commissioner. The Commission, on receipt of the aforesaid notice, shall deal with it as per section 29, 30 and 31 of the Act. Section 29 deals with the procedure for investigation of combination. Section 30 empowers the Commission to examine such notice and form a prima facie opinion as provided in section 21, subsection 1 of the Act. Section 31 provides for the order of the Commission on certain combinations. Let us now recapitulate what we have learned so far. It is a situation in a market in which sellers independently strive for buyers' patronage to achieve business objectives such as profits, sales or market share. It is the foundation of an efficiently working market system. There is no specific definition of the expression anti-competitive agreement, but it can generally be defined as an agreement which is contrary to or is inconsistent with the competition policy advocated in the Act. Dominant position means a position of strength enjoyed by an enterprise in the relevant market in India, which enables it to A. operate independently of the competitive forces prevailing in the relevant market, or B. affects its competitors or consumers or the relevant market in its favor. Section 5 of the Act deals with combinations which may create adverse effect on competition in the relevant market in India. Section 6 provides that no person or enterprise shall enter into a combination which causes or is likely to cause an adverse effect on competition within the relevant market in India, and such a combination shall be void. Thank you.